Hi, my name is Robert Shelley with Chelle Law, and my law firm assists physicians with employment contract issues. Today I'm going to talk about whether a physician can negotiate after signing a letter of intent. A letter of intent is also known as a offer letter. And so like the normal recruitment process would be someone is close to the end of their residency or fellowship, and then most people find a job through one of three ways. So either word of mouth amongst colleagues or mentors. A physician recruiter can reach out to them and say, hey, here's a position that might fit your needs, and then initiate the process that way. Or the physician can always find job opportunities through job listings, on the internet. So once kind of the process has been initiated and the physician is discussing with the physician recruiter the terms of the relationship, what's the salary, bonus opportunity, locations, that type of thing. At that point, many employers will then ask the physician to sign the letter of intent. And so in the letter of intent is just kind of the basic structure of the employment relationship. Start date, location, length of the contract, which is known as the term, how the contract can be terminated, compensation. So is it a base, what's the base salary? Is it RVU production, and what are the thresholds? Is it net collection, and what's the net collection percentage? And then the restrictive covenants, non-solicit, what are the terms of the non-compete? And then usually basic benefits. So what do they offer? Health, vision, dental, life, disability, retirement. What does the employer pay for as far as continuing medical education, licensing fees, DEA registration, associations, societies. So just basic things. All right, these are all the things we're going to provide to you. Now, some offer letters are more detailed than others, but if a physician is okay with the general terms of the offer letter, then the employer is going to say, we need you to sign the offer letter. And then at that point, we will then, get the employment agreement drafted, and then they'll offer the physician the employment agreement. Now, is the offer letter or letter of intent binding? Well, the answer is no, unless there's language in there that says it is binding. So it's very rare that you would find a letter of intent that states this is a binding document. And it doesn't make sense for a physician to sign that under any scenario for a couple of reasons. Basic terms in an offer letter with either no context or no other explanation can change substantially once we are able to see the actual language of the employment agreement. So maybe they state in the offer letter, there is a non-compete, but there's no description of it. Well, maybe you read the employment agreement and you're expecting a 1-year non-compete and they say it's 3 years, or you're expecting a 10-mile restriction geographically and it's 50, right? So kind of the initial offer letter may look like, okay, there's a non-compete. Well, that's expected for a physician. But once you read the actual terms, it goes from being, reasonable and okay to being completely unreasonable. So in that scenario, although the physician has signed the offer letter, they absolutely do not need to go through with signing the employment agreement. And then I would also suggest, even though the physician has come to terms with the offer letter, it doesn't stop them from renegotiating the terms prior to signing the employment agreement. As I said before, if once the actual language of the contract is reviewed, it can completely change someone's perception of a job. So maybe, okay, I'm willing to make maybe a smaller base salary if the non-compete is not as restrictive when I leave. Or let's say you have a claims made malpractice policy and the employer is saying, we will pay for your tail insurance once you leave. Well, maybe they would be willing to accept a smaller base because the employer will pay tail. And then maybe when you look and get the actual employment agreement in the language it states the employee has to cover their tail. Well, maybe depending upon specialty, that could be a significant amount of money. And then the physician may say, well, I had no idea I had to pay a $50,000 tail. And so therefore I want, a larger base salary to kind of offset that. So even after the physician signs the letter of intent, they certainly can continue negotiating once they see the actual terms of the employment agreement. Now, a couple considerations. One, it's not bad form to go back and renegotiate terms. However, some employers may get ticked off that the physician agreed to the offer letter terms and then came back again to renegotiate those terms. It can be off-putting to some employers. However, if the physician frames it in, well, you said that I would have this and I expected this to be kind of industry standard, but once I saw the language, it wasn't. For instance, let's say there's normally like a 60 to 90 day without cause termination, meaning either party can terminate the agreement for any reason with a certain amount of notice to the other. So they're expecting a 60-day without cause termination notice. And then the employer says, you have to give us 1 year notice. Well, that's insane. No physician should agree to that. And so they absolutely should renegotiate the terms once they see the actual language in the employment agreement. No physician should sign a contract that they're either unwilling to meet the terms of or are, significantly unhappy with prior to starting the job. There will always be push and pull when it comes to a contract. There is no perfect contract. It doesn't exist. There will be things that the physician has to relent on that maybe they're unhappy with, and maybe the employer has to relent as well as far as compensation goes, or having to pay tail, or any of the things I've already kind of discussed. But if both sides feel like relatively bad about the agreement, it usually means it was a fair negotiation. So if one side's like super happy, it usually means the other side is not. So don't sign an offer letter if you're not happy with the terms. But even if you do sign an offer letter that you're okay with, doesn't mean you can't renegotiate the terms after the fact. Now, it's possible you'd lose out an opportunity if you did that. An employer could theoretically pull a job offer. But in that scenario, I just don't think it's worth moving forward just because you don't want to tick off an employer. It doesn't make sense. So anyway, if you have any questions, you can always contact us at the phone number listed below in the description. Or you can always reach us through our website, ChelleLaw.com. That's CHELLE law.com. Again, my name is Robert Chelle, and appreciate you watching the video. Thanks.